Well, good morning. This is Ian R. Crane, and as you can see, I'm taking a break from taking a break. And I'm here at Southwark Crown Court once again with David Noakes and John Smith. And there's probably some 70 odd people, plus for the first time, a police presence, which I'm sure they have a good explanation for. But anyway, John, first of all, perhaps you can explain, what occurred in the court this morning.
At the previous court, we had spoken to Justice, who confirmed that he would deal with a challenge to his authority and jurisdiction. As it's been challenged, it requires a jury hearing, which he promised after being asked 3 times. We turned up today to find out, first of all, that there was no challenge hearing, there was going to be no jury, which requires, and also that in the interim, despite the legal team having been dismissed, the judge himself stated today that he personally contacted them to speak to them about what was happening, as he was concerned about David's health and well-being and his mental status because of stress it was being caused. He advised him to see a doctor. Now, the fact that the judge actually went behind his back and went to the opposing legal team, that in itself, we believe, is not only fraud, but it's also criminal collusion. So this is what the situation is in the court. We've turned around, which everyone's entitled to do, and challenge the authority and jurisdiction. The paperwork submitted, but instead of dealing with it lawfully and listening to it, he's decided to commit criminal coercion and proceed without having the authority to do so. He has not established authority, not established jurisdiction. We're not complaining about that. All we're saying is this has to be addressed with a challenge hearing. But he looked at the paperwork, which he said did see. Now, bearing in mind it had went in two and a half weeks prior to the last hearing, so therefore when he attended the last hearing, he should have, if he was doing his job correctly, should have looked at the paperwork, and therefore when he went into the hearing last week, he didn't want to deal with it. He assured us 3 times he'd deal with it today, and he said he looked at the paperwork for the first time after the last hearing. In doing so, in assessing the paperwork, he decided that it was not relevant and he wouldn't hear it. Well, the reason it's not relevant is because it's challenging his authority and jurisdiction, and it would find him out. Now, we have additional paperwork just now, which will obviously circulate to people and let them know, but to assist with the case we have just now, we have no better standing than approaching the government. So we have kindly got the government assistance from Scotland to assist in the process. The Scottish Government have set up a wonderful website for us to confirm what the situation is. Now, they have a website here, which is great, with a print off convening from Historic Environment Scotland. I'll just maybe flick that on there. It shows you, but what it does is it establishes facts about the Stone of Destiny. Now, the reason for highlighting this is the Stone of Destiny in point number 17 is confirmed by the Scottish Government that the stone, which they currently have and are passing off as the Stone of Destiny, is actually it's held by Historic Scotland, and it's in Edinburgh Castle. Point number 17, if I read out here, it says 2 years after the stone's return to Scotland, permission was given for the British Geological Survey staff to conduct a technical examination of the stone. The survey team carried out the works locked inside the Crown Room in Edinburgh Castle. The geological results were conclusive and confirmed that the stone was made from old red sandstone, which was quarried in the vicinity of Scone, which is in Scotland. So it confirms that the stone that they have, which was being used to coronate the Queen and appoint her Queen, which they also knew was fraudulent, they have taken the stone, used this to appoint the Queen, and the Scottish Government, having it examined, confirmed it has been done in Scotland. Now, the original stone came from Bethel. It was obviously transported centuries ago and it ended up in Scotland. The fact that all rightful, lawful kings and queens, it says, have to be sworn in, and the ceremony, according to the procedures, has to be witnessed by God, it says, or null and void. This actually cancels everything and goes right back to 1953. It's confirming that the coronation, in effect, has not been valid, and it also confirms that the appointment of all courts, judges, sheriffs, magistrates, it's all unlawful. They have no standing at all. And given the fact that we have this, we're going to put this in, but they refuse to accept it. They refused having a lawful power of attorney. They refused to accept that. They don't want to accept that. They didn't want me to speak or assist David on his behalf, which I'm entitled to do. Have not established authority within the court, so they couldn't do that. And what they've done is they've decided that they're going to put back the hearing on it, and they're going to deal with a confiscation issue for the remainder of David's assets. Now, in relation to that, they're not addressing the crimes. The issues of jurisdiction and authority, we're not in dispute. It says all we're doing is putting a lawful challenge to them, and the lawful challenge has to be held. If there is no issue with this and no problem, it will be held. The reason they will not hear it is because they do not have authority and jurisdiction.
But John, they're becoming increasingly aware that the level of awareness and knowledge of the fraudulent judiciary is spreading, which probably explains the police presence here today. So what we witnessed today is clearly a case of Judge Nicholas Lorraine Smith having been got at over the past week and basically told under no circumstances do you hear this case.
Yeah. As it stands just now, it says, look, there's not a dispute here. It says, we're not, obviously, it says the system exists, which is fine. I said, we don't question that. The situation exists, the statutory system, the judges, they have roles, that's fine. It says they also have a system here, and within that they can obviously deal with issues, legal issues, with your consent. It's not a problem, it's not an argument, it's a fact. Therefore, it says you also have a right to deal with this by stepping out with this system and removing your consent. In doing so, they have no authority. But when you do that, they're using criminal collusion to try and keep you in the system, attack you and hold you accountable in their system. That is a breach of every law it's possible. It is man-made law, it is common law, God's laws, natural law, universal law, United Nations. It's a breach of everything. They are committing crimes. They know what they're doing, and they're refusing to do that, and they're attacking innocent men and women.
So up until now, I mean, I gave Justice Lorraine Smith the benefit of the doubt on the basis that he was trying to do the right thing, but somewhat hamstrung by his robe. But clearly today, he's demonstrated that he's very much on the payroll, which we should never have doubted, of course, and that when push comes to shove, he will do precisely what he's instructed to do by effectively the Lord Chief Justice, which is to do whatever it takes to hang on to their fraudulent jurisdiction.
Yeah, well, a final comment to make is that while we were in court today, Justice Smith had turned around and stated, he spoke about the situation in relation to the legal team. He wouldn't allow me to speak. He didn't want David speaking, but he had to ask one or two questions. He tried to get him to say that he would go to see a doctor. He wants to ignore the challenge. He's told the legal team, although they have been dismissed weeks ago, he's told them not to resign and to hold in there. And the words he quoted was, "I ask you to hang in there for a couple of weeks." So basically, the legal team have been dismissed weeks ago. So this is done correctly. They've been notified, and people in the Strand are aware that the legal teams have been dismissed.
But what would have, John, what would have concerned the judge is that at the last hearing, David stated had to go that he was present as a living man. And of course, the judicial system can only be applied once you acknowledge that you're effectively dead, and can only appear with representation.
Well, what they're doing just now is they're accepting a position. David pointed out he was a living man today, which is fine. That takes him out of the system. Now, effectively within their system, which we've had other judges confirm, is that once you do that, they have admitted that they do not have personal jurisdiction over a living man. It's a fact. Now, that's established. However, what they're then doing is trying to grab him in there by using illegal fiction, which is criminal coercion. And that's what they're doing. So they're trying to drag him in and pull him in, and they're trying to prosecute him. It's unlawful and it's criminal, but this is what they're doing.
So, David, this is a real turn up for the books. I mean, on the basis of what we heard today, then Nicholas Lorraine Smith has actually deemed it to be an issue of mental health that you wish to introduce GC-MAF into the NHS and cure some 120,000 people from cancer every year.
Yep.
And the fact that you want to do that, that makes you, in the eyes of the judiciary, questionable in terms of your mental health.
Well, they always do this. If they look like they're not going to win a case, they always say you're bonkers, and they have. And I've allowed my team to get reports on me, realizing my team were going to use the reports against me. Now you are looking at Southwark Crown Court, which is in London on the South Bank, and it is an Admiralty court. And Admiralty courts, like all our courts in England, they're all Admiralty courts, can only prosecute ships, cargoes, dead seamen and their assets. So they have to pretend we're all dead. So if you stand up and say you're a living person and I have a birth certificate registered at court.com, they can't prosecute you. So they should already have struck out my case. In fact, they should have struck it out last time. But we are dealing with criminal courts and criminal people. And our freedom has been undermined by the EU dictatorship. Now, we knew when we went into the EU dictatorship around 1970 that England would become a dictatorship and we would lose our freedoms. There are 3,000 EU laws on the statute books and 150,000 regulations. That's 153,000 freedoms that the EU has already cost us. And we have to get common law re-established as the law of the land, or we will be serfs.
Hey!
Now, Lynn is still in Bronzefield Prison, very near Heathrow. Some days after submitting the writ of habeas corpus, he will be at least heard today. The judge has already said he will line up with the other judges. Well, they always do, they work together. But of course, Lynn is completely innocent. She did nothing in France apart from rent a house. She didn't work on GC-MAF, nor did I for that matter. But the MHRA told Oakless to prosecute Lynn and me. And they got the incredibly corrupt Judge Goddard, and he dreamt up 9 charges from his own imagination and put them on us. He didn't even bother to investigate. If he'd investigated, he'd have found that other people were doing GC-MAF in France, nothing to do with us at all. But the MHRA told him to prosecute, and so he's prosecuting. And so poor old Lynn may be going to France. We so much hope she does not. She is a completely innocent
and this,
woman.
of course, is extraordinary rendition using the European arrest warrant that was effectively set up to deal with terrorism within the EU, and it's being abused here to extraordinarily rendition Lynn to France, and yet this is yet more illustration of the corruption of the legal system working hand in glove with the corporatocracy.
Yep. So what Judge Goddard did is he put 2 GC-MAF companies together, one called Durzam, one called Cyto Innovations, and said they were colluding with each other, which allowed him to use the terrorism provisions of the European arrest warrant. So Lynn and I are arrested as terrorists in France. So that's for treating 9,000 people successfully with GC-MAF, 8,000 with diseases and 800 with terminal stage 4 cancer. And we are now classified in France as terrorists. That's the first abuse of the European arrest warrant, and they abuse it right the way through. But actually, of course, the whole thing is an abuse because the only reason the MHRA and Oakless are doing this is to conceal GC-MAF for another 25 years and kill another 120,000 people for another 25,000 years. That's what, sorry, 25 years. So that is what this is about. They are killing us, and they are determined that they will. continue to kill us.
And one actually has to question the sanity of a judge who actually dismisses the evidence. And in fact, once again, he made the observation that the hearing was not about GCMAF. Well, of course, it damn well should be.
Absolutely.
And, one has to question the sanity and indeed even the humanity of a member of the judiciary that just rides roughshod over the evidence, doesn't even want to hear it, about the efficacy of GCMAF, but instead wants to protect the corporatocracy.
That's correct. He's lined up with dark forces, and he is determined that GCMAF will never get out. In the courtroom today, he denied ever saying that he wanted to see GCMAF licensed and made available. Any normal person would want to see GCMAF made available to the public. It saves 120,000 lives a year. It saves 75% in our clinics. It'll save 75% in the NHS. 160,000 people die of cancer every year. If they do it badly, it'll save at least 120,000 of them. We got up to 89% success. Our Guernsey clinic, with the final one they closed, we got better every year. The next thing was we were going to treat leukemia and multiple myeloma. We already had it working in the laboratory. Now we had to get it working in human beings. And Lynn Thayer was the right person to do it. And if the MHRA had not stepped in, we would already be curing those two diseases. So we'd be up to 98% success with cancer. And when used by a lot of people, a lot of doctors in the NHS, we'll probably get to 100%. And they are determined that won't happen because they make $200 billion out of the poison of chemotherapy. And that is all they care about, money. They really don't care at all about human life. And it appears the people in this court do not care about human life either. And we have to fight for GCMAF, and we have to fight for common law, and we have to fight for freedom before we have none left.
Okay, so the next stage of the process is obviously to really make sure that people understand what's occurring here as readily as possible. And so I believe that we have a date of Wednesday, September the 11th.
Yes, I think, yes.
Which is the day that it's during the week that Parliament is actually back.
Yeah.
So, an interesting date, of course, as well, 9/11. But this is the day when you are calling people. September, the 11th of September, is the date that you are calling on people to come to Parliament. It's, because that is the week that Parliament is back before it recesses again. Wednesday, because Parliament will be packed because it's Prime Minister's questions. And this is the day that we need to show the parliamentarians that there is growing concern around the country about the suppression of effective cancer treatments up to and including cures.
Yep, so if you can make t-shirts which say GCMAF treats cancer and turn up outside the pub doors to the House of Commons over the other side of the road on Wednesday, the 11th of December.
September.
Sorry, 9/11.
Okay, so the actual meet time is going to be at 11:11 on the 11th of September. This year outside Parliament.
Yep, 9/11.
And
11 past 11.
We need this to be a massive event. I mean, anybody who has lost a family member to cancer or knows somebody who's currently going through the horrendous treatments prescribed by the NHS, i.e. chemo and radiotherapy, and knows that there are alternatives which the NHS shuts down, needs to be outside Parliament at 11:11 on Wednesday, the 11th of September 2018. Yeah?
Yep. Thank you very much. Yep.
Okay, so now I gather we're off to the Royal Courts.
Well, what I'd like to do is I'm going to point out some information. Lynn, I submitted a writ of habeas corpus for Lynn, which is one of our founding principles under common law. It's a right of everyone, inherent birthright, which has been deprived. They've unlawfully detained her in prison and they won't allow a hearing, which is entitled to. Now, we're not disputing whether or not what they've done is correct or incorrect, but the procedure says she has to get a hearing. They've actually left it, it's 12 days now they've had this, and it's been sitting in front of a judge. I was informed yesterday that the judge it dealt with is Sir Duncan, I believe it's Ousley. I'm not sure if that's the correct pronunciation, but I've also been informed he's a retired judge. Now, he's decided that he said he will not deal with the writ of habeas corpus. However, he understands, because we've put it in, he's prepared to give us a verbal hearing. Now, what we've done, he says there was a case that convened a couple of days ago to address what was happening in a common law court. So we put the information to a jury of our peers, and basically the jury of peers gave a court order saying that Lynn must be released immediately, that all assets must be returned immediately, and that David and Lynn can continue with their work. That's been done, he said, but the case was taken out against the Lord Chief Justice, so they've found him guilty for his failure to comply with this. So he's committed that. There is now a court order confirming that. The court order has been served, and we sent it out immediately, says, to additional people. Now, in this country, we have an ideal time for people to step up. Now, I'm not speaking about the public, because we know which side everyone's on. It says, in relation to the establishment, we've given them the opportunity to say, look, this is what's going on. Now, unfortunately, when you try to get a hold of someone in the establishment, you cannot get direct contact. So we've tried just to everywhere to get it, but we have actually submitted the information. So a copy of the common law court order against the Lord Chief Justice confirming Linda should be released immediately, that has went in, and we've actually asked the following individuals to look at it. We've asked the Queen to look at it. We've actually asked Boris Johnson to look at it. We've asked the Justice Secretary and also the Home Secretary. So they are aware of this. They're aware of the common law court order. They're aware of the crimes being committed and the unlawful detention of Linda Farrar. Now, if they are not prepared to address this, or even this issue and ignore it, well, we have no justice in this country. But these individuals who are employed and work for the people and are there to represent us, if they actually wish to step up, they can obviously try to assist with improving this existing system, but obviously protecting individuals' rights. They have it to do so. Boris has just been appointed. Says, now, I don't comment on politicians, but obviously he's there. Now, at the end of the day, I would imagine, as he's paid by the people, if he blatantly ignores a common law court order by the people, and he does not deal with this issue and allows it to continue without addressing it, is that the sort of individual that you want running the country?
Well, this is the acid test, isn't it,
Yeah.
really, for
Yeah.
people to show where they stand. Do they stand with humanity
Yes.
or with the corporatocracy, which
Yeah.
has no interest in humanity whatsoever other
Yeah.
than to fleece it for everything it possibly can?
Yeah.
So this is a tremendous opportunity because, right now 1 in every 3 people is forecast to contract some form of cancer in the course of their life. That's estimated to go to 1 in every 2 people by 2025, and every single person is expected to contract some form of cancer by 2040. And these figures are coming from the establishment, so they should know. I mean, that's their game plan. They're basically telling everyone what the game plan is, and that's of course why they want to suppress GC math. So they're right now, with the possible exception of Brexit. But I mean, this is an issue that should unite people regardless of their political persuasion.
Yeah.
Because cancer, I was going to say it doesn't discriminate, but of course I can't think of too many members of the senior establishment who actually die of cancer. So maybe it does. Anyway, John, David, I mean, obviously it's an ongoing situation. Lynn is still in this country at this moment. Obviously, hopefully we get some reaction from the habeas corpus hearing this afternoon. But if the establishment does the right thing, then they will release Lynn.
Yes.
And recognise that Judge Michael Supperstone, unfortunately, was also guilty of criminal coercion because he basically upheld the extraordinary rendition on the basis of zero evidence.
If this moment in time we have any resemblance of justice in this country, it says what they have to do is release Lynn. Now, what we're doing just now is we're not actually, at this moment in time, trying to do anything with him. All we're doing is highlighting what's happened. Now, at the end of the day, we're not asking for a challenge just now in relation to the issue of Lynn. We're not challenging, we're not disputing anything that's happened. All we're saying is there's an ongoing dispute. Now, as there's an ongoing dispute, and effectively there's two orders, they have issued an annulment order, the people have issued an annulment order. So therefore, you can't have both orders. So what we have to do is deal with this dispute. Now, until such time as this dispute is resolved, you cannot proceed. So everything must be stayed, and because she has been unlawfully detained, she should be released until this is dealt with. When such a time comes that we deal with the dispute, we can then move forward. If they are refusing to deal with this, well, we know what we're dealing with.
A corrupt judiciary.
Exactly.
Yeah, absolutely. Okay, well, David, obviously, unfortunately, your stress levels are going to continue to be high, but I mean, I have to say, I think you're handling it with remarkable aplomb, and I think for Judge Nicholas Lorraine Smith to question your mental health is disingenuous, to say the least, and demonstrates to me that Nicholas Lorraine Smith is a fraction of the man that I gave him the credit for in previous live streams. And in fact, I have to ask, Judge Nicholas Lorraine Smith, how the hell do you sleep at night? Because you have effectively condemned thousands to death.
That's correct. Absolutely.
You might as well have put a black cap
Genocide.
on.
Yes.
Yeah.
Yeah.
Anyway, so we'll keep people updated. I will continue to take breaks from my break when necessary, and maybe a further update this afternoon when we ascertain
As soon as we get one.
what transpires at the Royal Courts.
Yeah.
So, guys, thanks a lot. Big cheer for David and John.
Thank you very much. Thank you. Thank you.